All right, joining me once again here on the Matthew Filipowicz Show is my good buddy Steve Horn. Steve is an investigative journalist whose work has been seen in The Nation, The Guardian, Center for Media and Democracy, Alternet. He is a research fellow for DeSmogBlog, which you can find at DeSmogBlog.com. You can also follow him on Twitter at Steve_Horn1022. Steve, thank you so much for being on the show again.
Thanks for having me. Appreciate it.
All right, so Steve, a few weeks ago, about 3 weeks ago, there was a really, really disturbing court ruling when it comes to the Keystone XL, and it really didn't get a whole lot of press, but it really is a frightening ruling. Tell us all about it.
Yeah, so like you said, it was a few weeks ago, the U.S. Appeals Court for the 10th Circuit, which is located in Denver, Colorado, the court ruled essentially that on an injunction for the Keystone XL southern half, which is, according to the business press, going to be online and ready to pump out 700,000 barrels per day of oil from Cushing, Oklahoma, down to Port Arthur, Texas. They were ruling on if an injunction, which I'll unpack this more, but if an injunction was legal or illegal, a temporary injunction, while another decision is made on whether or not the permit for this pipeline was legal or illegal. So basically, they're trying to push through this pipeline before even the legality of how it was pushed through was decided. And the court ruled on kind of a test about injuries and who would be injured more. Would the environment be injured more? Or would TransCanada's corporate profits be injured more by an injunction while the court decides on the legality of the permitting process? And this court ruled that TransCanada's injuries for its corporate profits was more important and seemingly much more important based on my reading of the ruling than the environmental harms. They essentially looked at the environmental harms really only in what the water damages would be and sort of belittled how much water would cross over. And that was the kind of the scope of their looking at the environmental side of things. And it's kind of important to point out who the judges were. In a 2-to-1 ruling, two of them were Bush Jr., Bush Sr. appointees, one each, and then the dissent was an Obama appointee. And it's not even a partisan issue. Obama was very responsible for this Keystone XL southern half being built. He went to Cushing, Oklahoma in March 2012 and lauded the pipeline in front of the pipe yard, sort of a pipe yard from the pipes.
Gave a big speech standing in front of the giant pipelines, the giant pipes itself. Yeah,
exactly.
Yeah, no, that was a horrible moment for our supposed president who cares about the environment.
Right.
But go on.
Yeah, so long story short, he also issued an executive order saying that he approved of this pipeline being built in an expedited way. Has since passed 2 other executive orders that in total, he basically is saying that U.S. domestic pipelines should be permitted at twice the speed as they are already being approved. So that means less environmental scrutiny, less analysis, that kind of thing. And I think it plays right into what happened here with the way that it was permitted. A month before he made that speech, the Army Corps of Engineers was, which is just odd to begin with. They were tasked with permitting this pipeline. Normally, it would be the EPA through the National Environmental Protection Act. Well, they issued something called a Nationwide Permit 12, which usually is meant for projects that cross over waterways and other areas too, but are only about half an acre in size. What they had to do for the Keystone XL southern half, given that it's a 485-mile pipeline, is say that it was 2,227 single and complete projects. So they had to basically issue that many permits through the Nationwide Permit 12. And that's the way that they got away with ramming through the Keystone XL southern half, which is now being heard in a lower court at the district court level, also in Colorado. And they're deciding on the legality of if it should have been heard through the National Environmental Protection Act, which means that hearings have to happen, public hearings for the environmental impact statement. There are a 30-day hearing for the draft, a 45-day hearing for the final environmental impact statement. So there's much more democracy involved, much more say of the people versus this Nationwide Permit 12. There are no hearings. There's hardly even very much of an environmental impact statement. I think it's probably about 4 pages total. It doesn't really address any of the big concerns. So that's kind of the root cause of this is what the Army Corps of Engineers did. What this court was deciding on was whether an injunction should happen while that other decision's made, and that other decision will be made, probably sometime in the next few months, but it will be too late because this other court already basically gave the green light for the Keystone XL southern half to start, which will start in the beginning of 2014.
Unbelievable. So let's go over that stat again. So the way Obama fast tracked the southern half of the Keystone XL was he changed it from the normal approval process, which would have gone through the EPA, and he had it go through, what was it again?
Through the United States Army Corps
of Engineers.
Yes.
And so instead of being one project, but because it is one project, it is one giant ass pipeline
I do want to say that TransCanada even refers to it as at most two projects. They refer to the Keystone XL now, which is the northern half, even though
half.
They don't even say they don't even call the southern half really the southern half anymore. They call it the Gulf Coast project, but that would show that it's one project, right?
Right. So at most, even TransCanada calls this two pipelines, but they broke it up to 2,227 individual projects. That's how they actually got around this. How ridiculous is that? And just that they have to skirt everything so much to push forward this horrible pipeline. It's really, really sick.
It's really sick, and it's important to point out, as I think I did in my article, that this is becoming a new precedent for domestic pipelines, especially controversial ones. There's another one called the Enbridge, the pipeline that runs from Patoka, Illinois to Cushing, Oklahoma, the Flanagan South Pipeline. Essentially, they use the same exact process. It crosses over 2,000 waterways and streams and that kind of thing. And what they've done is the same thing. Said it's 2,000 single and complete projects. It's a 600-mile pipeline, same diameter, 36 inches. And I call that, if the Keystone XL northern half is never built, I kind of call that the new Keystone XL northern half, because it goes to Cushing, and that's what they need, is something that goes from the northern half of the U.S. down to Cushing, because the other one's going to go from Cushing down to Texas. So they're using the same exact process, and this same process is repeating itself right now for another controversial tar sands pipeline that goes from Alabama to Mississippi, another fracked gas pipeline in the Marcellus Shale area in the northeast United States. So this is becoming a new normal, and why this decision was really important, and I think vastly kind of under-examined by the environmental community, is that it's legal precedent now at the federal level. That now that if they have another challenge to one of these pipelines, they can point back to this decision and say, well, this court said that it was legal, so it's legal. And that's the dangerous part of it. It's sort of like, I think it's the environmental community's sort of citizens united for these big infrastructure projects, for how important of a landmark case this was, although I don't think most people are seeing it that way.